Your appearances for the record, please.
Yeah, good morning, Your Honor. You and your staff. My name is David Kamaj. My P number is 68273. I represent the petitioner who's here with me at my office.
Good morning to you both.
Good morning.
Your Honor, Jessica Bradley, Assistant Attorney General on behalf of the Michigan Secretary of State.
Good morning, Ms. Bradley. Whenever you're ready, you may proceed with your motion.
Here's some context. The woman in the bottom left got a DUI in 2019. Now she's trying to get her license reinstated. She had a hearing before the Secretary of State and she was denied. This is her appeal, and it's interesting. Just watch.
You may proceed with your motion.
Yeah, thank you. I filed this appeal on behalf of my client. Just by way of brief background, my client is 28 years old. She is a stay-at-home mother. She has one child that she takes care of, and she's 5 months pregnant, expecting another child on the way here. We had a hearing in front of the hearing officer, Harmon Higgins, back in January of this year. At that hearing, it was my belief that we proved by clear and convincing evidence that my client's drinking problem is under control and that she's a minimal threat to people on the roadway. Why do I believe that? Is we submitted a substance use evaluation done by Dennis Yeager. That substance use evaluation gave my client a good prognosis for continued absence. It was factually accurate. It indicated that my client had a mild disorder with both alcohol and marijuana. She testified at that hearing that she has not consumed any substance whatsoever since October of 2019. She testified at that hearing that she voluntarily attends outpatient counseling for her depression. She testified at that hearing that she takes her medication as is prescribed, and we submitted 4 letters, testimonial letters, notarized and executed by the person who signed them, all indicating that my client hasn't used the substance since October of 2019. I say that because the hearing officer denied my client based on an alcohol reading on July 7th of 2021. My client testified, what?
There were 2, right? It wasn't just the one on July 7th. There were 2 positive readings.
I thought there was one. There were 2 positive readings on July 7th, one of 0.03 and the other, I think it was like 30 seconds later, 0.030.
Oh, okay. So both readings were on the same date.
Yeah, it was on the same day, and it was a
Okay,
relatively.
my apologies. I misunderstood. Please continue.
Oh, no problem, Judge. So, yeah, it was the same day. Typically, when you see these alcohol readings, you see more than just one. People typically fall off the wagon. They start drinking again, and you'll see multiple days with multiple readings. That's not what we have here. My client testified at the hearing that she didn't know why it detected alcohol, that she hadn't consumed alcohol that day or the night before. She actually testified that she went to the Westland Police Department in an attempt to get a PBT reading, but the Westland Police Department told her that they were closed for COVID and they were not doing PBTs. So she had to rush over to her sister's house because she was going to watch her sister's kids that morning because her sister had an appointment, rushed back to her house after she watched the children. About 2 hours and 45 minutes later, blew 000. We waited 15 weeks for the decision. My client's been on this device now for 20 months. She has no other criminal history whatsoever. She was going through a tough time in her life back in 2019. Her mother passed, and shortly after that, her dad killed herself. You look at all this evidence, Judge, and the reason why I say it this way is the law says, you don't look at one thing. You don't cherry pick one day or one incident. The law clearly says that the hearing officer is required to look at the evidence supported by competent material and substantial evidence on the whole record. Now, the legislator put that in there, I believe, for this specific reason. Look at the totality of the circumstances. Look at where she was and where she's at. There are few people, Judge, that will admit they have an alcohol problem and that will voluntarily go to outpatient counseling to deal with their mental health issues. That's what she's doing. She's not court ordered to do that. While she was on a restricted driver's license, she didn't pick up one ticket. She's not on probation, not on parole, nothing. She's a stay-at-home mom trying to watch her child. She doesn't work. This device, and she got herself into the situation. I get it, and she gets it. But this device is $250 every 2 months. They're barely getting by. I just think now 20 months on this device with one bad day where my client testified, and I thought testified pretty credible, that she did not consume alcohol that day. I'm hoping, Judge, based on all of the evidence that I've submitted to you, that you find that the hearing officer's decision was contrary to the evidence of the whole record, that it was arbitrary. And I'm asking you that you grant my client a full driver's license. I think it's time now. If you deny this, she's going to probably go 2.5 to 3 years on this interlock device. I just think that's excessive. I think the hearing officer did not review the whole record. I think he used this day and said, you know what, too bad, so sad. I don't believe you. People always have issues with these devices.
All right.
And there are way too many people driving around in this world that I love to have any sympathy for someone who chooses to get behind the wheel and drive. Very rarely am I sympathetic. But this case, I'm not sure.
Your response on behalf of the people.
Thanks, Your Honor. With regards to her substance use evaluation, unfortunately, she did not let the evaluator know that she had tested positive for alcohol on this date. And she didn't testify only once. She testified, or she didn't find positive only once. It was within the same date, and moments later, she again was positive for alcohol use. Now, she's not supposed to be using any alcohol. What she didn't do, and she said she spoke to her attorney, who told her that she needed to get a breathalyzer within an hour. She says that she drove to the police station. Police station wasn't available to do breath tests. However, I cannot believe that the attorney wouldn't also mention that she had to, if she couldn't get a breath test within an hour, that she would have to get an ETG within 24 hours. She never completed that ETG. She said she didn't know where her order was, and that she no longer, she may have read it earlier, but she didn't remember it. That's fine. However, because she did not, in all essence, clear out that device, and because she did not show that she was no longer using alcohol, she did not get that test within 24 hours. This is not clear and convincing evidence that her substance use issue is under control. And again, Your Honor, we ask that you affirm the hearing officer's decision. He was good enough to put her back on restricted driving privileges. So we want to see her maintain her restricted driving privileges. All she needs to do is show that there is no alcohol use, and that is tested by the interlock device. If she goes back and there's nothing else, we would assume that the hearing officer will find that she is now clean. But right now, she does not show that she has her alcohol use issues under control. Thank you, Your Honor.
Ms. Bradley, do you agree that the last positive on the interlock device was in 2021?
Yes, Your Honor.
She's continued to have the interlock device where she's had to blow to operate her vehicle for 2 years.
Yes.
And there's been no further positives.
No, Your Honor.
So we want her to continue to blow for how much longer?
Until she's able to prove to the hearing officer that her substance use issue is under control. And
what more would she need to do?
She'd be eligible.
Wait, hold on. Let me finish my question. What more would she need to do? She's provided proof that she successfully completed this program. She's continuously blown on the interlock device to start her vehicle for 2 years. For 2 years with no positives. What more would she need to do?
Your Honor, I don't make that decision. That is to the hearing officer.
I'm asking you, what more do you think she needs to do?
I believe that she needs to show clear and convincing evidence that her substance use issue is under control. That would be by maintaining sobriety throughout her restricted period, and be able to show that she has clean device.
She's had this restricted license for how long, Ms. Bradley?
2019, 2021, 22, 23. I think about 3 years.
Okay, so in about 3 years, there's been 3 positives or 3 failures. One when her car was in a dealership and she didn't have access to the blow on the device. One when the battery died or something, and one where she has no real explanation but denies use of alcohol, but let's just say she really did use alcohol. Let's just say that I believe she really did use alcohol back in 2021 when she tested positive. You think that one use of alcohol in 3 years
Your Honor,
is a demonstration that she does not have her substance abuse under control?
well, if she did use alcohol in that time and she didn't admit it, then yes, that is a problem.
Okay. Is there anything else you want to say, Miss Bradley?
No, Your Honor.
All right. Any rebuttal argument you'd like to make on behalf of the petitioner?
Your Honor, just looking at the order that the Secretary of State entered, this was mailed out on April 18th, 2023. It indicates that my client's eligible to go back 1 year after, I believe, this order was sent out. So potentially, if you deny our requested relief, we would go back to the Secretary of State in April, wait 2 or 3 months for a decision. Probably she would be on the interlock device for going on 3.5 years.
And I would like to correct one thing he just said. It's from the date of the administrative hearing that she would be eligible to go back. And
Okay.
the hearing was in December,
January.
January. So she would be eligible in January of 2024, Your Honor.
Oh, yeah, you're correct, Ms. Bradley. I misread that. Thank you. She would have to be on the device, probably, practically thinking, Judge, the rest of this year and a few months next year. So in total, 3.5 years on the device. I just think based on the record as a whole, that's a bit extreme.
Okay, well, so here's what I think. I think that when you look at the situation, and you look at what the type of violations there are, I think that it appears that he must have the administrative law judge must have assessed this as if she had 3 minor violations within a monitoring period. Would that be correct, Ms. Bradley?
Yes, Your Honor. She was coming in for full license, so everything would be looked at.
And in this instance, he indicate what was it, a male or a female administrative law judge?
I believe it was a male. It was a hearing officer, Harmon Higgins.
I don't want to misgender somebody. Okay, so his order indicated that she should continue to use the interlock device, and that she can return in January. She could petition for another review, correct?
Yes, Your Honor.
That's correct.
She's the stay-at-home mom. She doesn't work. Where does she need to go?
That's just she that has activities for her 2-year-old that she takes the child to. She would like to work once her baby's born and get a job and help out. But
she's pregnant right now?
Yeah, she's pregnant. She's 5 months pregnant. Yeah. But
And her baby's 2 years old. So that means that in 2021, when this alleged violation occurred, the most recent alleged violation occurred, she would have been pregnant then.
She did have her kid. She had her child, like I want to say 5 or 6 months before this.
5 or 6 months before that incident?
Correct, Judge.
Did she breastfeed that baby?
Yes. Yes, Judge.
So you can't drink and breastfeed, can you?
Absolutely not.
You're not supposed to, Your Honor, but you
But
can.
people do, I guess. Yeah, you're not supposed. I guess what you're supposed to do and what people actually do are 2 different things. Under the circumstances here, I think that the petitioner is correct. I think that she's entitled to relief here. I think that I think that I'm going to grant the petitioner's relief, and I'm going to restore her license. I think she's under the circumstances here, I just think that if you look at the totality of the circumstances, she has a reasonable explanation for 2 of the 3 violations. I'm not so sure how I feel about her explanation for the most recent one, but even if I do assume that she had relapsed and has some alcohol, she still had a period of 2 years of sobriety, demonstrated sobriety subsequent to that, because that was in July of 2021, and here we are in July of 2023, and she's been blowing on that interlock device consistently for 2 years with no further violations. And to me, that seems to me to demonstrate that she does have her alcohol use under control, and that she's earned the right to have her license restored. So I'm going to grant your the appellate relief.
Thank
I'll
you, Your
put-
Honor.
I'll put the order together. Thank you, Judge.
All right, have a good day.
I think the judge got this one right. And I really can't figure out what the prosecution was fighting for, because it didn't seem like justice. Let me know what you think in the comments. Until next time.